Yeah, I don't care about exhibit two. What else you got?
Okay. Two. How do you feel about three?
Three's fine.
Four?
What is four again?
Those are the picnic benches.
Which park? Which
I
camp?
bel- I believe it's the campground. Let me make sure. Exhibit four is a photo of Hayman Grove picnic area. Yeah.
Yeah, I mean, I don't have any objections to it. I don't
Okay.
care if it comes in.
Okay.
Five, the Roman candle.
I don't have a problem with five.
Okay.
Cool.
Six.
Six is what? The other one, Danville?
Is that the
No,
Danville
six is
one?
like the
Danville?
smoky photo, yeah.
Heyman or Daleville?
That's a good question.
Good question.
Let's make sure
Let's,
we know all these.
yeah.
Yeah.
Six is the Daleville campground.
Okay.
Okay, I think I don't know that we wanted. I think we're good without six, unless you guys want it
Um,
into it.
do you have any objections to it?
To six, no, we can pre-admit it.
Yeah, let's pre-admit.
Okay.
Okay.
Seven,
Seven, I would like to lay foundation for it.
that works.
8A,
Yeah, we would like 8A.
okay. Uh, that's fine. 8B,
This is just the continuation, right?
it's a later day, I think.
Oh, I'm sorry.
Oh,
I
yeah, it
didn't
is. Yeah.
scroll all the way.
8B is July 8th. It's after the incident.
Okay. Um,
It's up to you.
just reading it, make sure. Yeah, I think AB is fine.
Okay. And 8C,
That's fine too.
okay. So I just want to make sure that I'm clear about what exhibits we entered here because it seemed like we entered all but one.
Yeah, just about.
Okay, so
Um,
seven is the only thing that needs to be proved up. Everything else is in.
Unless I have no objection to nine, the your expert CV or resume. I don't know if
I
okay.
never enter a CV.
Okay.
Okay,
No
cool.
problem. So everything, or we didn't talk about one. That's the transcript.
Oh,
So
yeah.
one is pre-admitted by stipulation.
Oh, okay. Missed that part, but we'll add that in.
Okay, so
Yeah, so
one through
everything but seven.
six, 8A, 8B, and 8C are in, right?
Yes,
And nine is not in. So we are not admitting seven and nine.
correct.
All right, you guys have any motions?
Yes, we have one.
All right, what's your motion?
So we would like to keep out any mention of the prior shoplifting arrest under relevance, improper character evidence, and it being more prejudicial than probative
Prior shoplifting arrest for whom?
for both of them.
Okay, well, so if we agree that we're keeping it out for your witness, Kelly Lutkin, then we just want it out for the defendant as well.
That's fair.
All right, no mention of shoplifting. It's not relevant anyway. Okay, and that's it for you?
Yep.
Okay, in our expert report, there is a statement in the conclusion that says either fire could have been independently sufficient to burn the storehouse down. We want to exclude that statement under 401 and 403.
Okay. Yeah, we would definitely, that's actually right when you said that, I had a feeling it was going to be the line that we wanted. So
Okay, so you don't agree to it.
I do not. We'll have
All
to
right,
take
we will take it up.
okay. And
Okay,
just to
guys,
clarify, it's just the one line that you guys are MILing, not the whole conclusion?
not the whole conclusion, just that
Okay.
line.
Okay. Gotcha. Okay. Is that the only emotion you guys have?
That's it.
Okay,
Sweet. Good
cool.
luck, guys.
All right, let's go ham.
Fine.
That should be a good problem.
Jeffrey, check your messages, please.
So just so we're all on the same page in front of the judge for housekeeping, just because it's Zoom, so the only like relevant things are like pre-sworn, everything pre-admitted, or the list of the pre-admissions,
Oh,
constructive like approaching and everything.
well, also, identification of the defendant, we need to establish that as
Oh,
well,
yes, yeah.
just in order.
All right. Y'all figured out everything?
Yes, ma'am.
Does the problem not give you a defendant to identify?
Right.
No,
All right.
just,
Your defendant is sitting at defense table wearing a blue shirt with red trim, Seppi.
That looks familiar.
thank you.
That way you just have somebody to ID. That being said, the court calls this the case of State versus Weiss, and I will turn it over to the Honorable Judge Denise Brown. Good luck, everyone.
Good afternoon, everyone. If I could get counsel's appearance, please.
Yes. Good afternoon, Your Honor. My name is Alejandro Castellanos, and I'm here alongside my co-counsel,
Good afternoon, Your Honor. My name is Maddie Settles.
and we're the prosecution.
All right, and defense?
Good afternoon, Your Honor. My name is Anthony Lane for the defendant, Adriana Weiss, joined by co-counsel.
Good morning, Your Honor, or good afternoon, Your Honor. Sorry, my name is Jeffrey Medina.
Your Honor, our defense is ready to proceed to trial pursuant to a few housekeeping matters and a motion in limine.
Okay, and is the prosecution ready for trial as well?
Yes, Your Honor. Likewise, pursuant to housekeeping and an agreed upon motion in limine.
Okay, let's take up housekeeping first.
Okay, thank you, Your Honor. First and foremost, we just would like to make sure that all witnesses have been constructively pre-sworn.
Yes.
And when publishing exhibits, would you like us to ask each and every time or just the first time?
Just the first time.
And is the court okay with all the pre-markings that have already been denoted?
Yes.
Other than that, if the defense doesn't have any housekeeping, we have a agreed upon motion in limine that we would just like to read into the record.
Okay. Defense, do you have any housekeeping at this time?
Yes, Your Honor. As you know, because we're on Zoom, we will have to display exhibits on our screen. Whenever we need to prove up an exhibit, can we assume that it is constructively being shown to the witness outside the presence of the jury?
Yes.
And once it is admitted, may we freely publish to the jury at any time?
Yes, you may.
Your Honor, we have agreed to the pre-admission of some exhibits. I don't believe we've gone over those yet. May I go over them now?
Yes, and then we'll take up the motion in limine.
Yes, Your Honor. We had a successful pretrial conference with the prosecution, and we have agreed to the pre-admission of exhibits 1 through 6, as well as exhibits 8A, 8B, and 8C. We have not agreed to the pre-admission of exhibits 7 or 9. So we would request Your Honor's permission to move those exhibits into evidence at this time.
Is that agreed to from the prosecution?
Yes, Your Honor.
All right, those are pre-admitted.
Your Honor, that concludes the defense's housekeeping matters. We're ready to move to motions.
Okay, let's take up the prosecution's motion in limine.
Yes, Your Honor. And again, in the pretrial conference, when we met with defense, this was an agreed to motion in limine. We have agreed to keep out any mention of either one of our complaining witnesses or the defendant's prior shoplifting arrest.
Okay, what else?
That concludes the motion in limine for the prosecution.
All right, let's take up, well, defense, do you have any motion in limine?
Yes, Your Honor, we have one. Your Honor, this is a case about an arson based upon the spreading of fires. We will be calling an expert witness to the stand today, and that expert has made a conclusion about whether these fires would have been sufficient to burn down a property that was burned based upon the spreading of the fire. So the expert specifically says in his conclusion, either fire could have been independently sufficient to burn the storehouse down. We seek to exclude that one statement under 401 because it is not relevant. They are required to prove that the fire actually caused it. Whether it was possible is not relevant in this matter. We would also seek to exclude it in the alternative under 403 because it misleads the jury.
Whose expert is this?
This is our expert, Your Honor.
And you're wanting to exclude one of your own experts' opinions?
The single statement just because it does not actually go to one of the elements in this case.
That's denied at this point, but feel free to bring it back up.
Understood, Your Honor.
Is there anything?
I apologize, Your Honor. That concludes our motion in limine. We're ready to proceed.
All right, is there anything further before we get to opening statements?
No, Your Honor. Prosecution's ready to proceed.
All right, prosecution, you may start with your opening statement.
Thank you. May it please the court. You play with fire, you're going to get burned. Good afternoon, ladies and gentlemen. My name is Alejandro Castellanos, and alongside my co-counsel, Maddie Suttles, we represent the state. Now, this is a case about recklessness, not intent. Because on July 4th, 2023, the defendant didn't wake up planning to burn anything down, and no one here is claiming that. But that's not what the law requires. The law is going to ask you something more simple and much more narrow. Did the defendant knowingly or recklessly start a fire, and did that fire put someone else's property in danger? And over the course of today's trial, ladies and gentlemen, I have a feeling that the evidence will reveal just that. Now, on the evening of July 4th, the defendant and their friends or college-age adults gathered at the park to celebrate the holiday. Now, you'll learn that earlier in that day, they made a decision. They decided to drive out of the state to buy fireworks, specifically Roman candles, which, for anyone who's unfamiliar, is a type of firework that shoots exploding balls of fire into the air. Now, these weren't unfamiliar objects. These weren't kids who were sneaking off to buy fireworks. These were adults who knew exactly what they did. And that night, in the Hayman Grove picnic area, an area that's surrounded by trees, by dry brush, by summer vegetation, they lit those fireworks. And they lit those fireworks near those woods, knowing what they did, knowing that they shoot fire. And not long after, you'll learn that a forest fire began. Now, you'll hear from Deputy Matt Fernandez, the responding officer on the scene. And he'll tell you how he arrived at the park late at night to find firefighters who were battling a growing fire. He'll describe what witnesses told him about how fireworks were being set off earlier that night. And you'll hear how beneath the picnic table where the defendant's group was sitting, he found a leftover Roman candle. Now, he'll also tell you what happened after. He'll tell you how the fire spread through the woods onto private land and ultimately burned down a storehouse that belonged to a local farmer. Now, ladies and gentlemen, you won't have to speculate about that storehouse being burned down as a result of a forest fire that originated at the park. It's a fact. You're being asked today to decide the cause of that fire. Now, you'll also hear from Kelly Lutgen, who's one of the defendant's closest friends. And Kelly will get on the stand and she'll be honest with you. She'll be honest with you about everything, the good, the bad, and the ugly. Now, you'll hear that at first she didn't want to talk to the police, that she may have denied the fireworks were involved, and she'll explain why. She'll explain that the defendant was her friend, She'll explain that she was scared to talk to the cops. It's not something she's used to doing. But you'll also hear that when confronted with the evidence, she told the truth. She told the police what she'll tell you here, that the defendant was the one who lit the fireworks. Kelly will explain that she understood then that setting fireworks off in a dry, woody area is a risk, and one that they ignored. Now, ladies and gentlemen, the defense hired an expert in this case, an expert who they paid to opine on the cause of the fire. And they might get up here, and I anticipate they might tell you about another fire that started, a fire that was in Daleville. Now, we aren't trying to hide that fire to you. We want you to know about it. But the only fire that matters in today's trial is the one that was started by the defendant. So we'll ask that you don't let a literal smokescreen distract you from why we're here. Because the law doesn't require the state to prove that the defendant's fire was the only fire, or even the one that reached the building first. At the end of the trial, the judge will instruct you that there may be more than one cause, and that a defendant is responsible if their conduct was a substantial factor in creating the danger. Now, when my co-counsel gets up in closing arguments, she'll talk to you about the burden of proof. And that burden of proof is beyond a reasonable doubt. She'll explain it to you, but I want you to know that we welcome that burden, that we're going to meet that burden. She's going to explain to you your jury charge, and she's going to walk you through how you should fill it out. Now, lighting fireworks in a dry forest isn't some sort of unexpected event. You don't not know what's going to happen, because fire does exactly what you expect it to. It burns, and it burns, and it spreads, and it spreads. Now, this isn't a case about punishing their celebration, taking away from the 4th of July. It's about responsibility. Because when someone introduces a fire to the forest and that fire spreads and damages someone else's property, the law holds them accountable. So at the end of the trial, when you go to deliberate, when you look at all the evidence, after you've heard all the testimony, we are confident that you will return the only verdict that is consistent with both the facts and with the law. Guilty. Thank you.
Defense, would you like to do your opening now or reserve it?
We would like to proceed with our opening statement.
Great, you may proceed.
Thank you, Your Honor. May it please the court. Unreliable sources. This case is about unreliable sources. Now, ladies and gentlemen, you just heard the prosecution come up here and they told you that there was a forest fire. And that forest fire broke out and it led to a storehouse being burnt down. But ladies and gentlemen, what they conveniently left out is that we don't know the source of that fire. Unreliable sources. Ladies and gentlemen, my name is Jeffrey Medina, and along with my co-counsel, Anthony Lane, we represent the defendant, Anthony Wise. Now, ladies and gentlemen, the prosecution has the burden of proof in this case. That means they must prove beyond a reasonable doubt every element of 4th-degree arson. And through the facts and the evidence of this case, you will learn that they cannot and that they will not meet their burden. You will learn that there were 2 fires that night. you will hear from prosecution witness that there was a fire that started because during the campground, while they were partying, the wind started to pick up. The wind started to pick up. People are unattending these fires, and the fire gets out of control. Unreliable sources. You're going to hear from the officer who responded to the scene that night. And he's going to tell you that he doesn't have any physical evidence of how these fires started. He knows that there were fireworks, but he doesn't know how that caused the storehouse to be burnt down. Now, ladies and gentlemen, he didn't see who lit this fire. There's no fingerprints, no DNA evidence. Unreliable sources. You're going to learn that this officer, he interviewed the defendant's best friend. And you're going to hear how this main investigative source was intoxicated. Unreliable sources. Now, ladies and gentlemen, prosecution has the burden of proof in this case. They don't get to ask you to guess or to speculate about who started this fire and how this storehouse got burned down. They must prove their case beyond a reasonable doubt that Andrew Wise started this fire. And they cannot and they will not meet their burden. At the end of this trial, my co-counsel, Anthony Lane, will come up here and he will break down everything that you heard throughout this trial. He will tell you how all of these sources are unreliable. Now, we as the defense, we don't have a burden in this case. That is the prosecution's job. But we will bring an expert to you, and he will tell you that there is no way to know which fire started this forest fire that burned down the storehouse. There's no way to know. At the end of this trial, we will ask you to find the defendant and Adrian Wise not guilty. Thank you.
All right. Prosecution, please call your first witness.
Prosecution calls Kelly Lutkin. May I proceed?
Yes.
Ms. Lutkin, could you please introduce yourself to the jury?
Yes, hello. My name is Kelly Lutkin.
And do you work right now?
No, I'm currently in college.
Do you know the defendant in this case?
Yes, I have been best friends with Miss Weiss for ever since we were 9 years old, so about 20 years now.
And how would you describe your relationship with her?
I mean, we're super close. We grew up together. She goes to a different college than me now, but I mean, we've been friends for all of our lives. Almost like a sister to me.
Ms. Lutkin, do you remember July 4th, 2023?
Yeah, I do.
What were you doing that day?
So that day I got up in the morning and, it was July 4th. So I had reached out to Andrea to see if she would want to go with me. A couple of our friends, a friend group, we all had plans to go out to this picnic area at Hayman Park. So I texted and asked her if she would want to come with me.
And what were the plans for that night?
So when I reached out to her, I thought it would be fun to go get some fireworks. She agreed to do that with me, so we drove about 45 minutes away, to Indiana, where we picked up some, they're called Roman, fireworks, and then we headed on over to the picnic site.
Your Honor, at this time, may I publish what's been previously admitted as Exhibit 8A?
Yes.
Thank you. Sharing my screen here. Ms. Lutgen, are you familiar with this text exchange?
Yes, I am.
How are you familiar with it?
So these are the text messages that I was referring to earlier, on the day of July 4th of 2023 with Andrea.
Now, just for clarity, who is sending the gray texts
Me,
and who is sending the blue texts?
Andrea.
So what was the first thing you said to her?
So like I said earlier, I reached out to her. I was excited. It was the 4th of July. I wanted to see if she would be willing to come with me and go get some fireworks.
And just so we're all clear here, what did those emojis mean?
So they're firework emojis, little boomsticks.
And how did she reply?
Well, so she told me sure. She just wanted to shower and then she would be good to go with me.
Now, this is a continuation of that text exchange. From here, after you guys made plans to go and get them, you mentioned that it's 45 minutes away. How does she respond?
I mean, she thought it was kind of far. She wanted to know if it was worth it. But I mean, she said she was just wondering, so she was gonna, I understood it to mean she was gonna come with me no matter what. She was just wondering why it was so far away.
And how did this conversation end?
I promised her that I would cover the gas money, we would take my car, and then she said, yeah, just let me know whenever you're on the way.
Thank you, Ms. Lutgen. Stop sharing here. Is my screen gone for you?
Yes.
Okay. Now, where in the park were you guys?
So we were specifically at the portion of Hayman Park that the picnic area. There were a bunch of those wooden picnic tables that people typically sit on. That's where our group of friends had set up our group hangout site.
And what does the surroundings look like?
It was, a pretty green area, but we were surrounded by a forest, a lot of grass, trees.
Now, being that this was the 4th of July, what, if anything, was unique about the weather?
I mean, it was pretty hot. I guess almost dry, you would say, really humid. Um, yeah, it was pretty hot that day.
And was this where you guys ultimately lit the fireworks?
Yes, it was.
Now, what kind of fireworks did you end up buying?
So we ended up buying the Roman fireworks. They are kind of skinny. Um, they kind of look like just a little candlestick, maybe, if you will.
And could you just explain to the jury how they work?
Sure. So with the Roman fire sticks, you just light them, and then they kind of go off from there.
Now, when in the night did you guys decide to begin lighting fireworks?
Um, I believe it was towards the end of the night.
Who lit them?
Um, so it was my idea to buy the fireworks, but when we got there, Andrea was just really excited about them. So she asked if she could be the one to light them.
Now, I just want to clarify, Miss Lutgen, when you're saying Andrea, do you mean Adrian?
Yes, excuse me. I mean, Adrian.
And up to this point, when you referred to Andrea, you meant Adrian, correct?
Yes, I'm sorry. I'm a little nervous. I've never testified before.
That's okay. Um, so when she lit these fireworks, what did you see her do?
Well, she took the firework, she lit it, and then they just went off. I just, sorry, it's a little overwhelming thinking about it now, but yeah, I mean, everything just went off all at once. And of course, we didn't realize that it would happen, but there was a fire.
And which way was she facing when she lit this firework?
Um, toward the, I believe it was toward the forest line, toward the trees.
Was this the direction the projectiles were ultimately fired?
Yes, if I recall.
Now, do you remember after this incident talking with law enforcement?
Yes, I do.
What do you remember about that?
So I was brought in by the police, and they started asking me, if we were lighting fireworks that day. And to be honest, I was just a little bit nervous. I'm 20, I'm in school, I have a full ride to the university that I'm attending. I was kind of scared. So when he asked if I had used the fireworks at the campsite, I said no.
And did you later explain the truth?
Well, the officer, after I told him that we didn't have any fireworks, the officer indicated to me that they had reports from other people that there had been fireworks at our site. Um, Again, I was still a little bit scared to tell the truth. I didn't want any of us to get in trouble, me or Adrian. So again, I said no. And then he let me know that they actually had photos of fireworks at our campsite, um, and that if I didn't say anything, then I would get in trouble for arson. So then I decided that it would be best for me to tell the truth.
So what was the truth that you told the officer?
I mean, like I said, I didn't want to get Adrian in trouble. Uh, but I did tell the officer that Adrian was the one who lit the fireworks that day.
Now, Kelly, do you want to be here testifying today?
Objection, relevance.
Sustained.
Is that all you want to, or Kelly, do you want to be saying this about your friend?
Objection, relevance.
Response?
Your Honor, this witness has already explained how she initially gave an inconsistent statement about what had happened because she didn't want to get her friend in trouble. I'm just simply trying to rectify that now in anticipation of any cross-examination.
Your
That
Honor.
objection is overruled.
Yes, Your Honor.
I'll ask you again, Kelly. Do you want to be saying this all of this about your friend?
No, I mean, like I said earlier, me and Adrian have been friends since we were 9 years old. Um, I really didn't want to throw her under the bus like that. That wasn't my intention. But if I said something, I would have gotten in trouble, and if I didn't, I would have also gotten in trouble. So I just felt like at the end of the day, it was better to just finally come clean. And I do understand that, there are consequences for me now as well as her, but I just wanted to be honest.
Thank you, Kelly. Pass the witness, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
Yes.
On direct examination, you said, I apologize. Hello, Ms. Letkin.
Hi.
Ms. Letkin, my name is Anthony Lane. I'm going to ask you a couple questions real quick, okay?
Mhm.
On direct, you said you didn't want to throw Adrian under the bus. Is that right?
Yes.
Ms. Letkin, you understand you're under oath today, right?
Yes.
You understand that your oath is that you tell the truth,
Yes.
and that your oath is that you tell the whole truth.
Yes.
Ms. Letkin, you have a difficult relationship with the truth. Is that fair to say?
Um, if you're referring to the police interview, I mean, I was just scared when he said it was going to be a felony charge. But I do understand that it was wrong to lie.
And I want to just take a moment. I want to talk about those because just to make it clear, you were interviewed by a police officer about what happened, right?
Yes, the
That,
fire.
that officer asked you if you had anything to do with those fireworks.
Yes.
And you told him, no, no, we didn't have anything to do with those fireworks, right?
Right. At the beginning, I did say no.
And you said you were just hanging out and enjoying the night.
Yes.
That wasn't true, right?
Yes, like I've said, it wasn't true.
The officer again asked you, are you sure you didn't have anything to do with those fireworks, didn't he?
Um, yes, and then he told me about the reports and the evidence, and I honestly just got more scared and I realized I better be upfront about it.
Ms. Lecken, I appreciate that, but don't get ahead of me just yet, okay? Step back with me. The officer asked you, are you sure you didn't have anything to do with it, right?
Yes.
And you said, no, I swear I didn't have anything to do with it.
Yes.
You said it must have been someone else.
Yes.
That wasn't true, was it?
Again, no, it wasn't.
You also told him that we saw other people with fireworks, but it wasn't us.
Yes.
That was the third lie that you told him, correct?
Yes.
And it was after he told you that if you continue to deny, that's when you changed your story, right?
Well, it was after he told me that I was going to get arrested for arson, I realized, that it was pretty serious and I better be honest.
Because you have a lot to lose, right?
I mean, yes.
And let's be clear, if you admitted that it was you, then you would be charged with arson, wouldn't you?
Yes, I understand that even now admitting my role, that there will be consequences for me.
When you told him, but I didn't set them off, I swear.
No, I didn't set him off. It was Adrian, but I did buy them.
I appreciate that. You told him then, after lying to him 3 times, that it was Adrian.
Yes, because it was.
You told him it was Adrian after he threatened to charge you with arson.
Yes.
You said that Adrian was really excited and said she wanted to light him, correct?
Yes.
On direct, you talked about some text messages. I'd like to show those to you again. Your Honor, at this time, may I publish Exhibit 8A?
Yes.
This is the text message that you were shown on direct, right?
Yes.
Okay, Ms. Lucken, I just want to be clear about what happened here. You reached out first, right?
Yes, I believe I said that it was my idea.
Yeah, and you said, are you down to come get them with me, right?
Yes.
And I want to be crystal clear because on direct, you talked about these little firework emojis. You were referring to fireworks when you sent that, right?
Yes, of course.
You also said, I did some looking and we got to go in for the Romans, right?
I was referencing we got to go to Indiana. The acronym IN is for Indiana.
And for Romans, you meant the fireworks.
Yes.
Now you said Adrian expressed some hesitation, right?
I mean, I don't know exactly why. I was assuming it was because honestly, they probably didn't want to cover the gas money, so that's why I let them know that, hey, I'm going to pay for it. I know it's kind of far, but
I
I got
appreciate
it.
that. I don't need you to assume anything, so I'll just read this and you tell me if I read the message correctly. Adrian said, damn, really? Is it really worth it?
Yes.
And you said, yeah, I love me some fireworks on the 4th of July. Did I read that correctly?
Yes.
So I just want to be clear, you were the one who was pushing this idea of getting these fireworks.
Like I said, yes, it was my original idea.
It was your idea to drive 45 minutes away to buy them.
I thought it would be a fun thing for the 4th of July.
But your testimony today is that you didn't like those at all.
No, once we got there again, she got really excited and she wanted to be the one to do it.
So it was your idea, but all you did was watch.
Yes.
After this incident happened and after you spoke with the police, Adrian was arrested, right?
Yes.
Charged with felony arson.
Yes.
Adrian reached out to you and asked, why did you tell the cops that she was the one who set off these fireworks?
Yes.
You told Adrian that, well, you know I can lose my scholarship if I don't.
Right. If I would have lied and said it wasn't her or said nothing, the officer said I would have gotten a felony charge. I didn't want to lose my scholarship for not saying anything.
So it's your testimony today that you had no role in this whatsoever.
No, I admit that I did have a role, but I didn't light them.
I see. It was your idea, but you didn't light them.
Yes.
You were the one pushing Adrian, but you didn't light them.
I don't know if I would say pushing. It was the 4th of July. She was down to do it with me. I don't know if I would say I pushed her. But again, it was my idea, yes.
I appreciate that explanation. You're the one that suggested driving for 45 minutes, but you didn't light them.
No.
Your Honor, may I publish what's already been pre-admitted as Exhibit 8B to the jury, please?
Yes.
Now, Adrian was pretty upset with you after this, right?
Right.
Because Adrian was charged with a felony.
I mean, no, I get it. I do. I get why they were upset.
When Adrian confronted you about it, what you said was, and tell me if I read this correctly, they told me they were going to do that to me too, or I wouldn't have told them you did it.
Yes.
You know I can't lose my scholarship. If they had actually charged me, I wouldn't have been able to play. Did I read that correctly?
Yes.
And then Adrian said, look, I get that, but you can't just throw me under the bus like that, right?
Right.
No further questions for this witness at this time, Your Honor.
Any redirect?
No redirect, Your Honor.
All right, the witness is excused. Prosecution, please call your next witness.
Yes, Your Honor, the prosecution now calls Maddie Fernandez.
You can proceed.
Hi, Mr. Fernandez. Could you please state your name for the record?
Yes, my name is Maddie Fernandez.
What do you do for a living?
I'm a deputy here in Hocking Hills County.
How long have you been doing that for?
I've been doing it for some time now, I can say.
Are you familiar with Lake Hope State Park?
Yes, I am.
Where is that park located?
That park is located here in the state of Eureka. It's a spot where people go to celebrate different holidays and such.
I want to turn your attention to July 4th, 2023. Were you on duty that day?
I was on duty that day.
What happened while you were on duty that day, if anything?
Well, at approximately 11:45 at night on the 4th of July, I got a call. I got a call about a fire in the Hayman Grove picnic area located within Lake Hope State Park.
Once you received that call, what did you do?
Well, I decided to go check it out. Dispatch had informed me that multiple parties had called to report this fire, some coming from Hayman Grove picnic area and another spot called Daleville Campground.
Okay, well, when did you arrive?
I arrived shortly after at around 11:57.
And what did you do when you first arrived?
Well, the first thing I noticed was the significantly in progress fire that was being fought by the Hocking Hills County Fire Department. So I began to look around to see if there were any witnesses that could speak to how the fire began.
Were there any witnesses?
There was.
And who did you run into?
I ran into a person that I later identified as Dario Maciel.
And what did the two of you discuss?
We discussed where he had been that entire evening, and he pointed my attention towards a group that had already left at that point that was acting obnoxiously.
What group are you referring to?
I now know that that group was Kelly Lutkin and
Yes,
Adrian.
Your Honor, hearsay.
I'm sorry, you were cutting out a little bit. What is your objection?
Hearsay, Your Honor.
Okay, response?
It goes to the effect on the listener, Your Honor. This is a police officer responding to the scene of a crime.
May I respond?
Yes.
Yes, Your Honor. The information that was relayed to this officer is hearsay. The prosecution has not laid any foundation for what the effect is on this listener.
May I respond, Your Honor?
Yes.
I believe we have laid proper foundation, Your Honor. He received a call and was dispatched to the area of a crime, and now he's just responding. We just laid the foundation that he will now be taking witness statements.
Anything further, Mr. Medina?
No, Your Honor.
Okay, your objection is overruled. You can proceed.
Yes, Your Honor. Now, once you found out who that group of people was, what did you do next?
I went to go investigate where they were located before they had left.
And what area were they located in before they left?
They were located in a table in the northwest corner of the clearing.
What did you observe in that area?
In that area, I saw remnants of Roman candle firework.
Officer, could you tell us what a Roman candle is?
Certainly, I took pictures of it as well. A Roman candle is a type of firework that's a stick that you light and it shoots outwards, essentially balls of fire.
Your Honor, may I approach the witness and also publish to the jury pre-admitted Exhibit 5?
Yes.
Officer, is this what you just described?
That is exactly what I just described, yes.
And did you happen to find any of these in the area?
Yes, this is the specific picture I took of the remnants that I found at the campground. Well, excuse me, at the picnic table.
Thank you. Officer, once you found this firework, what did you do?
Well, continuing investigation, I found out that these fireworks had begun being lit around 10 p.m.
Well, now knowing this, what was your plan next?
Well, considering I knew who the suspects were, considering I knew the identities of the people who were potentially around these fireworks, I called dispatch and I had them provide me the addresses and the phone numbers for both Adrian Weiss and Kelly Lutkin.
After being provided with their contacts, did you ever contact either of those individuals?
I attempted to call both of them, but neither of them answered me that night.
Did you ever speak with either of them afterwards?
I was able to speak with Kelly Lutkin the next day.
Was there a transcript of that conversation?
Not of that conversation. That one took place over the phone, and we scheduled an in-person meeting where she came in, and we did file a transcript for that second conversation.
Would you be able to recognize a transcript of that conversation if I were to show it to you?
I would.
Your Honor, permission to approach and publish with already admitted Exhibit 1.
Yes.
Thank you. All right. Okay, officer, what am I showing you?
You're showing me the transcript of the conversation between myself and Kelly Lutkin.
Could you kind of tell the jury what this conversation was about?
Yes, absolutely. So, because she was one of the suspects involving the Roman candles, I had to ask some questions about it. I had to see who lit the candles. I had to see how this fire was started. I had to ask a lot of these different questions. And a lot of these preliminary questions here are asking exactly that of Kelly.
And how did Kelly respond to those questions?
She began by denying any allegation outright or any question involving any involvement in these fireworks.
Well, after she denied it, what did you do?
Well, I urged her and expressed how important truth was in investigations such as these. Because we already had eyewitnesses see fireworks starting starting the fire at 10 p.m., I had to see who was involved with these fireworks. And I then let her know of the potential risks she takes by not being fully truthful.
And once you told her about those risks, did anything change?
Yes, she told me the truth.
What was the truth?
That Adrian Weiss lit the fireworks and started the fire.
Now, after having that confession, what did you do?
Well, I had to act on it. I contacted dispatch and requested a warrant for the arrest of Adrian Weiss, and then I executed that warrant the next day.
And during your investigation, did you come to like meet Adrian Weiss?
Not until I arrested her at her home on the 7th of July.
Do you see Adrian Weiss in the courtroom today?
I do.
Could you please point her out to me and identify her by an article of clothing that she's wearing?
Yes. She's standing over there at the defense stand in the blue shirt with the red lining.
Your Honor, may the record properly reflect that this witness has properly identified the defendant.
Yes.
Now, you just said that you arrested Miss Weiss. What charge did you arrest her with?
I arrested her with 2 charges. One of them, the one that's being litigated today, 4th-degree arson. And the other one, her being a minor in possession and consumption of.
Thank you. No further questions at this time, Your Honor. I pass the witness.
Cross-examination?
Yes, Your Honor. May I proceed?
You may proceed.
Officer Fernandez, you weren't there when the fire started,
That's correct.
so you didn't witness any person set off these fireworks?
That's right.
You didn't witness how any of these fires started?
That's right.
Now, you mentioned that when you arrived, you spoke to a Dario Marcel?
Yes, Maciel.
Yes, and he told you that fireworks had started being set off around 10 p.m.,
Yes, and that was the beginning of the fire.
but he didn't tell you who specifically lit those fireworks.
No, he pointed my attention to the group.
I appreciate your answer, but that wasn't quite my question. My question was, he didn't tell you specifically who lit those fireworks.
That's correct.
So you don't have any specific information on who actually lit those fireworks.
Yes, I do have specific information on who lit those fireworks.
You just stated that you don't know, or he didn't tell you who lit those fireworks.
He didn't, but Kelly did.
Right. Let's talk about Kelly. Now, you later interviewed Kelly.
That's correct.
This was at the station.
Yes.
And before Kelly identified who lit these fireworks, she lied to you multiple times.
That's right. It's kind of a common occurrence when you have people shaken up by police.
So that's a yes to my question. She lied to you multiple times.
Yes, I began with yes.
And that's when you threatened her that she was facing arson charges.
I wouldn't call it fully threatening. I just made her aware of the possibilities of what could actually happen to her with what she had done.
Right, you made her aware by threatening her that if she didn't cooperate, she could be facing arson charges.
Just saying it how it is, counselor.
So that's yes to my question. And that's when she changed her story.
That's is when she changed her story, yes.
And after you threatened her that she was facing arson charges, that's when she identified Adrian Wise as the person who lit this fire.
I still don't know if I agree with the term threatening, counselor, but yes, if you would like to represent it that way.
So you used this pressure, or you used this threat of arson charge as pressure during this interview with Kelly.
Yes, counselor, I had to get to the bottom of who started this fire.
And that's the only information, or that's the only way you found out that it was Adrian Wise who lit this fire.
There were other ways.
No further question.
Any redirect?
Briefly, Your Honor.
You can proceed.
Mr. Fernandez, you mentioned that there was a fire. Did you later learn whether any property was damaged by this fire?
I did. Pat Green's storeroom was damaged and he lost about $500,000 worth of equipment in it.
Objection, Your Honor. Relevance outside the scope of my cross.
Response?
Your Honor, they just discussed a fire. I'm just asking what this fire caused.
It is technically outside the scope of the cross,
Yes, Your Honor.
but I'm going to go ahead and let you proceed.
Yes, Your Honor. And did you go to that property?
I did.
Where is this property located?
It's located on the northwest area of the entire Lake Hope Park in the forest.
Is just to be clear for the jury, is that here in the state of Eureka?
It's in the state of Eureka, yes, here in Hocking Hills County.
Did you take a photo of that scene?
I did.
Your Honor, permission to publish to the jury and approach the witness with already admitted Exhibit 3.
Yes.
Is this a photo that you took?
It is.
Now, following your interview with Kelly, who did you arrest?
I arrested Adrian Weiss
Why?
because I had more evidence that pointed that Adrian Weiss caused this than Kelly Lutger.
Thank you. No further questions, Your Honor.
Recross if it's permitted.
No recross, Your Honor.
Okay. The witness may be excused.
Thank you, Your Honor.
Prosecution calls their next witness.
That's all of the witnesses, Your Honor, but before the prosecution rests, may I have a moment to confer with counsel?
Yes, you may.
Thank you. Okay, Your Honor. Before the prosecution rests, we would like to read into the record a stipulation.
You may do so.
Thank you. And we,
You want to do it constructively?
no, we would like to actually read it.
Okay, you can proceed.
Thank you. I'll point the court's attention and opposing counsel to stipulation 3. Pat Green's storehouse burned down as a result of the forest fire originating at Lake Hope State Park on July 4th, 2023. And with that, the prosecution rests.
Okay, defense, you can call your first witness.
Yes, Your Honor. Before we proceed with our case in chief, we do have a motion that we would like the court to hear outside the presence of the jury.
All right, the jury's been excused and you can proceed with your motion.
Yes, Your Honor. We move for a motion of judgment of acquittal, Your Honor. As you're aware, the prosecution has the burden of proof in this case, and based on the evidence that they have presented here today, they have not met their burden. Specifically, they have not proved that the cause of this fire was by the defendant Adrian Wise, and that this fire did in fact burn down this building and caused this explosion or this damage to occur. Therefore, we move for a motion of judgment of acquittal.
Response?
Yes, Your Honor. So you have heard testimony here today that Adrian Wise, the defendant in today's case, had access to these fireworks. You saw the text messages that she went with her friend Kelly to go retrieve these fireworks. Kelly testified that she was the one that fired these off. Now, Your Honor, I just want to be clear. It's fair for the jury to understand that we do not have to prove that this fire alone caused the damage to this property, but rather that it was a substantial factor in the damage to that property, which we have proven today.
Mr. Medina, anything further?
No, Your Honor, we stand on our motion.
Okay, I'm going to deny that motion. You can call your first witness, please.
Yes, Your Honor. The defense calls Casey to the stand.
You can proceed with questioning.
Good morning. Good afternoon. I know you, but would you please introduce yourself to everybody here in the room?
Yes, my name is Casey Machado.
And could you tell us a little bit about yourself, Mr. Machado?
Of course, yeah. I'm 55 years old. I love the outdoors. I've been working at Lake Hope State Park for quite a while now, and I love my job. I get to work outside at the park all the time.
What do you do at the state park?
So I'm in charge of the Daleville campground, host kind of is what I call the title, but I upkeep the place. I take care of events. I take care of the property on that area of the state park. I'm there to make sure that everything stays safe and that people aren't getting a little too crazy out there.
Now, directing your attention to the events that happened on July 4th of 2023. Were you at the park that day?
Yes, I was.
What were you doing at the park?
We were hosting a party out at my campground at the Daleville campground. So we had a bunch of people out there, and I was out there basically just hosting, celebrating the holiday.
Now, you just mentioned that you were hosting a party. Who was at this party?
Well, it was me. I had a friend Judy there, and then there was a bunch of people at that campground. So I don't know if I recall exactly who all was there, but there was a lot of people at the party.
And what sorts of things were you all doing to celebrate at this event you were hosting?
Objection,
You know,
relevant.
it's
I'm sorry, your objection relevance?
Yes, Your Honor.
Okay. Response.
Yes, Your Honor. He's explaining what happened, what transpired during the events of this party, the party where the prosecution is accusing the defendant where he started this fire. This is a fact of consequence, and it is more probative than it's probative. So it's right.
Okay. I'm going to overrule the objection, but keep it short, please.
Yes, Your Honor. What sorts of things were you doing at this event?
the typical 4th of July party. So there was eating, drinking. There was a few fires here and there at the campgrounds, like normal.
And were people drinking alcohol at this event?
Yes.
Did you have any alcohol at this event?
I was celebrating with everybody, so yes, I had some drinks.
Now, you mentioned that this was a 4th of July celebration. Did you see anyone setting off any fireworks?
I didn't see any fireworks. I heard something around 10 o'clock that sounded like it could be fireworks, but I didn't see who might have set them off or if anybody was actually doing that.
Now, let's discuss some of the events that took place later on during that evening. Did the celebration continue after you heard or you thought you heard there might be fireworks?
Yeah, the party was still going after that, but the wind started picking up real bad, and that's kind of when things took a little bit of a turn.
What do you mean by things took a little bit of a turn when this wind picked up?
Well, one of the fires that was set at Campground 27 right there, if somebody wasn't watching it and it kind of got out of hand, it spread and kind of took off right after that.
I'm going to object at this time, Your Honor, to speculation.
Response?
This is the witness is not speculating. He's not speculating to what others have seen. He's simply testifying to what he saw during this time of the events. He's not speculating.
May I respond, Your Honor?
Yes.
This witness just testified that at campsite 27, someone wasn't watching it, but I didn't hear any foundation that this witness would necessarily like witness that or has any knowledge of that.
Okay, the objection is sustained at this point. See if you can lay a foundation.
Yes, Your Honor. Now, I want to take a step back with you. You had mentioned that there was a celebration going on, correct?
Yes.
And during this celebration, what sorts of things was going on?
Objection asked and answered.
Overruled.
People were drinking, singing, typical party stuff. Everybody was kind of just roaming around the campgrounds.
And were there campfires lit?
Yes.
And were these campfires always attended to?
Objection calls for speculation.
Your Honor, he's testifying to what he perceived at the time. He's not speculating. He's testifying to what he would have saw.
May I respond, Your Honor?
Yes.
From what I gathered, there are at least 27 different campfires. This witness only has 2 eyes, so I'm unsure how he's able to see all 27 campfires at the same time.
May I respond?
Yes.
This witness works at the campgrounds. He is able to monitor and walk around. He would have been able to see if there were campfires unattended to.
May I respond, Your Honor?
And he can testify to that.
May I respond?
Briefly.
If there was some foundation laid that this man was walking around and monitoring, I would be fine with that, Your Honor. But right now I'm hearing that he was drinking and partying with everyone else.
I'm going to sustain the objection right now. Y'all can proceed.
As you're here at this event, what are you doing?
And I was walking around the campgrounds, but I was also, drinking and enjoying myself at the same time.
And as you were walking around, were there campfires unattended?
Objection
Yes.
calls for speculation.
Overruled.
As you were walking around, were there campfires unattended?
Yes.
When you saw that there were campfires unattended, what did you do?
I didn't do what I should have done at the time until the one at Campground 27 actually got up and out of the area and started spreading.
And when you saw that this campfire had got out of control and it was spreading, what did you do?
Well, I ran over there and tried to put it out myself, but it was useless at the time. The wind was too strong, so I couldn't handle it myself.
Was there anyone around you to help you?
At that point, anybody that was near was panicking and everybody was kind of running in different directions because it was spreading pretty quick.
Now, around what time did all of this take place?
This would have been around 10:45 or 11. Like I said, I wasn't really paying attention to the time, but it was around 11, 10:45, 11.
And as this fire got out of control, did anyone call the fire department?
I called 911 as soon as I realized that I couldn't put the fire out by myself.
And did the fire department end up arriving?
Yes, they did pretty quickly after that.
And what happened after they arrived?
After they arrived, I had to talk to the police, um, and just give a short statement.
You mentioned that you spoke to authorities,
Yes.
and did you give a statement?
Yes, I did. I talked to an officer a little bit later that evening.
And were you under the influence when you gave this statement?
Yeah, it was that same night, so I had had drinks throughout that evening before I talked to him.
Were you ever notified of the results of this wildfire?
I found out that Pat Green's storehouse burnt down later on.
No further questions, Your Honor, at this time.
Cross-examination?
Yes, Your Honor, may I proceed?
Yes.
Good afternoon. Now,
Good
you are the
afternoon.
campground host at Daleville Campground, is that right?
Yes.
Part of your job is helping keep the campground safe.
Yes.
And like you testified on direct, that means that you monitor campfires.
Somewhat, yeah, when I need to.
On July 4th, 2023, you were drinking alcohol while on duty, right?
Yes, ma'am, I was.
And people around you were drinking as well?
Yes.
Now, you're aware that when the deputy spoke to you later that evening, you were visibly intoxicated, true?
Yes, I had had quite a few.
And because you were drinking, you were not watching every campsite closely, right?
Not like I should have been, no.
You mentioned campsite 27 on direct, right?
Yes.
Let's be clear. You were not standing at campsite 27 the entire evening, right?
No, I wasn't.
So you didn't see who started that fire at campsite 27?
No,
You do not know how long that fire had been burning before you noticed it, right?
the campfire, no. It would have been a while, but I don't have an exact time now.
I want to talk about the conditions that night. So the wind was kind of rapid that night, wasn't it?
Yeah, it really started picking up.
And by the time you tried to intervene, you said that the fire was already growing.
Yes.
But earlier that evening, you heard fireworks, right?
I think it was fireworks, yeah.
At around 10?
Around 10, yes.
I want to be clear for the jury. You are here to talk about the Dayville fire, right?
Yes.
You're not here to offer any evidence about the Heyman fire, right?
No, I don't know anything about that.
And just so I'm clear, you have no experience in being a firefighter or anything like that.
Firefighter, no.
So you cannot tell this jury what caused the fire that burned down that storehouse, true?
No, I just know that there was a fire on my campground.
Thank you. No further questions, Your Honor.
Redirect?
No redirect, Your Honor. May we just ask that this witness be excused?
The witness is excused. Defense, please call your next witness.
Yes, Your Honor, the defense calls Cal Stewart to the stand.
All right, you may proceed.
Dr. Stewart, good afternoon. How are you?
I'm doing well. How are you?
Dr. Stewart, can you go ahead and introduce yourself to the jury, please?
Sure. My name is Dr. Cal Stewart.
What are you a doctor of?
I have my PhD that I got. I got my MS in fire and explosion investigation, and then I got a PhD in fire protection engineering.
What does that mean?
Sure. Fire protection engineering is, well, part of my job at Stewart Consulting, where I do my business. We help communities, especially rural communities, prepare themselves and protect themselves before a fire breaks out or while a fire is going on. So it's basically a study in, fire protection.
And what are the functions that you do in that business?
Sure, we consult people and we sort of prep them, or we consult engineering projects mainly. So if something is getting built, something's being created, we tell them the risk of it, maybe what the exposure to fires are, and how to combat these problems.
And why were you asked to testify in this case?
Sure. Well, part of my experience and part of my education is in fire investigation, what caused them, what the sources were. So I was asked to look at two fires. A fire that started at Campsite 27 in Daleville, we'll call that the Daleville fire, and then a second fire, a fire started in the Hayman Grove picnic area. We can call that the Hayman fire.
Okay, I want to talk about that with you, but first I just want to ask you a couple of little foundational questions here. Is that okay?
Sure.
Now, Doctor, what did you rely on in order to look at those fires or to investigate those fires?
Sure. I relied on my own personal knowledge, experience, and expertise doing what I've done for the past years of my life. I also, in preparation for this testimony, I looked at various exhibits and statements by the witnesses as well.
Did you ever visit the sites of the fire?
I did.
And Doctor, is that are those methods relying on the exhibits and all of the affidavits in this case, as well as going out to the site? Are those common methods used by experts in your field?
Yes, sir. They are.
Is that a reliable method in order to come to a conclusion?
Yes, sir.
Did you base your conclusions upon reliable principles and methods throughout?
Yes, sir, I did.
And did you apply them to the facts in this case?
Yes, sir, I did.
And were you able to come to any conclusions in this case?
I was.
Your Honor, at this time, we offer Dr. Cal Stewart as an expert in wildland fires.
Any objection?
No objections.
He is admitted as an expert.
Your Honor, at this time, may I publish what's already been pre-admitted as Exhibit 2 to the jury, please?
Yes.
Just a moment, I apologize. Okay, thank you for your patience, Doctor. What is Exhibit 2?
Exhibit 2 is a map of the Lake Hope campground, and then the subparts of it, the Daleville campground and the Hayman Grove, where the fires broke out. And then I see a red X at Pat's Green Storehouse, which is the place that burned down as a result of fires.
Okay, so throughout the testimony today, I don't feel like I've gotten a clear picture. So I'm going to ask for your help to guide me through this. You said there were two fires. Where was the first fire that you,
Sure.
Excuse me, not first fire chronologically, but let's just talk about the first one in whatever order you prefer.
Sure. We can start with the Hayman fire. So as you can see on the map right there where it's marked Hayman Grove. The Hayman fire originated in the forest about 50 feet from a picnic area clearing. That's where that fire started. And then that fire is a result of a firework that went off. Is that where you want me to go, or do you want me to move on broadly to the next fire and then go into?
Let's just take it step by step, Doctor. If
Sure.
I need to ask you any other questions, I'll ask you. So why is Hayman Grove important in this case?
Hayman Grove's important in this case because that is where the defendant, Adrian Weiss, was at the time of the fire, and it was caused by a firework.
And approximately how far is Heyman Grove from Pat Green's storehouse?
It's approximately 0.4 miles.
And is that straight line distance?
Yes, that straight line distance. Where the fire traveled as a whole is different, but we'll get to
Okay,
that.
we'll get to that, Doctor. Now let's talk about the Delville campground. Why is that important?
The Delville campground is important because, as the previous witness, Mr. Machado, explained, that is where another fire occurred from a poorly managed fire ring, a small ember, a smokestack almost, as you will, that occurred at a site called Campsite 27 in Delville campground.
And approximately how far is Delville from Pat Green's storehouse?
Straight line distance, 0.7 miles.
Okay, so I want to talk about the work that you did before we actually talk about the fires. So when there has been a fire, what is it that you actually do?
So there's a process, right? So one thing I like to do is I like to go to the burn site. The very first thing I do is I want to understand what the characteristics of this place is like the lay of the land. How did this fire break out?
How does that help you?
That helps me because it lets me understand one, it's for deductive reasonings. I'm able to get things out. This didn't cause it. That didn't cause it. I'm able to see the origin source. I'm able to pinpoint the origin source. I'm able to get a feel for environmental conditions. And that's when I can begin my process of analyzing burn patterns next.
Okay, so I want to talk about these burn patterns.
Okay.
Did you, based upon this map, forgive me, what did you learn about the Heyman site?
Sure. Well, for starters, the Heyman site, the first thing I want to get into was the cause, which was a firework. And that is, oh, go ahead.
Doctor, if I can interrupt you for just a moment, I apologize. How do you know it was a firework?
Sure. The lay of the land in the Heyman fire, there was no footpath connecting the origin point to the clearing. And there was no evidence of lightning strike or any sort of weather that would cause maybe a spark in that area. And so it makes sense that there was a projectile. And obviously the criminal investigation took place and they found, I believe it's called a Roman candle. And that was the most likely source of the fire.
Now, do you know after the fire started where it went?
Sure. And this is important for a few things. Let's talk about environmental conditions.
Doctor,
go ahead.
Before we get there,
Sure.
you said you know where it went. Did you ever diagram this for us?
I believe I did.
Your Honor, at this time, I'd like to display Exhibit 7 constructively outside the presence of the jury. It has not been admitted into evidence yet.
You can do that.
Okay, Doctor, can you see that?
Yes, I can.
What is Exhibit 7 without going into the content?
Exhibit 7 is a map of where the fires occurred and my diagram of where they traveled and their paths.
And how are you familiar with this?
I'm familiar with it because I marked it up.
And is it a fair and accurate copy of the map that you created?
Yes, it is.
Your Honor, at this time, we move to admit Exhibit 7 into evidence.
Any objection?
No objections.
Exhibit 7 is admitted.
All right, Dr. Stewart, talk to us about the fire at Heyman Grove.
Of course. So at Heyman, Heyman in this area in general, we're dealing with a dry, late summer vegetation. So right then and there, we already have risk of a fire spreading quickly. So that's one thing. I then viewed the burn patterns at the scene.
What did that tell you?
Right. So when I'm looking at burn patterns, I look at where they're headed. What way are they going? It's like footprints with fire. And then the depth of the char marks, which shows how hard and hot the heat was burning.
And were you able to find it? I apologize. Were you able to find the answer to that or where it went?
Yes. After locating a stream near Haman, I found that the fire was traveling towards that stream, and that stream caused that fire to change course, where it eventually headed straight for where the Daleville fire was developing, where it converged with the Daleville. It combined.
Okay, let's move down to the Daleville campground. You said that started from fires in the area. Which way did it travel?
Sure. As you can see from the diagram, it was more straight line. You can see this sort of bubbling effect that the pink arrows at Haman were having, swooping down, that's caused by the stream. But Daleville, you see more of a straight line path towards the storehouse, and you see where both arrows intersect. That's where it combined into one flame.
Which of these fires burned down Pat Green's storehouse?
I wish I could give you a conclusive answer, but it's quite impossible to do so. The reason why is because these fires intermingled together. When the stream caused the Haman fire to change course, it pushed it straight towards the Daleville fire, where they became one. And at that point, it's almost like putting water into water. You can't determine what the exact source was.
Do you know who caused the fire at Daleville campground?
Daleville fire was caused by a mismanagement of a smoke ring, or a fire ring, by Casey Machado, who I believe was the campground host.
Do you know who caused the fire at Haman Grove?
Objection, Your Honor. Calls for a legal conclusion.
Response?
I'm just asking him if he knows, Your Honor. I'm not asking for a legal conclusion.
If I may, Your Honor.
Yes.
In the alternative, I believe it'd be highly prejudicial for the jury to hear an expert have any sort of opinion on who started the fire, when that is the very thing they're here to decide.
Response to that?
Yes, Your Honor. I'm not asking the expert to have an opinion. I'm asking him if he knows who started the fire. That doesn't invade the providence of the jury at all.
Objection is overruled.
Dr. Stewart, do you know who started the fire at Haman Grove?
No, I just know that the likely answer was a projectile firework.
No further questions for this witness at this time, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Dr. Stewart.
Hello.
Now, you were hired by the defense in this case, is that right?
Yes, I was.
And you were asked to analyze fire origin?
Yes.
As well as the spread?
Yes.
Now, just generally speaking, you'd agree with me that fireworks can start wildfires?
Yes.
In fact, it's your opinion that a firework did start a fire near the Haman Grove picnic area, right?
Yes.
And that fire was near where people were setting those fireworks off, right?
Yes.
Now, Dr. Heyman, Roman candles as a firework, they shoot burning projectiles, right?
Yeah, sure, yeah.
And in dry vegetation, those can ignite a fire, right?
Oh, yeah.
Now, I want to talk about just the Haman fire itself. You determined that it originated about, I think you said 0.4 of a mile, or 0.4 of a mile from Pat's storehouse, right?
Yes, 0.4. I know it's hard over Zoom. 0.4.
I appreciate that. You also concluded that in the absence of any other fire, the Haman fire could have independently burned down the storehouse, right?
Objection, Your Honor. May we approach?
Yes.
Your Honor, at this time we would renew our motion in limine. And this does not go toward the actual causation of this fire. It's just a hypothetical.
Your objection to the question? Or you're objecting to what your motion in limine was?
I apologize. Yes, it's renewing the motion in limine, Your Honor. The objection.
Okay. And for the record, what was that?
The objection was under 403. It misleads the jury. The prosecution is required to prove that the fire caused damage to the building or was a substantial cause. A statement that it could have been or it would have been does not go toward that causation.
Response?
Yes, Your Honor. As you know, causation is the central issue in this case. You know, just because the opposing counsel isn't happy with what their expert opined on doesn't mean they can cherry pick parts of that opinion. I believe that hearing an incomplete opinion would prejudice the jury more than not.
Mr. Lane, anything further?
No, Your Honor, I stand on my objection.
Your objection is overruled. You can proceed with your questioning.
Thank you, Your Honor. I'll ask that again, Dr. Stewart. You also concluded that in the absence of any other fire, the Hayman fire alone could have independently burned down the storehouse, right?
Yes, either fire could have done it, but yes, you are correct.
So if the Hayman fire were the only fire burning that night, it still could have destroyed the storehouse?
Yes, it could have.
Now, I'd like to shift your attention to the Daleville fire. You also found evidence of that second fire, right?
Found evidence?
Or,
No,
excuse
not
me,
me.
reviewed
Yeah,
evidence.
just yes. I heard the testimony and I examined the case file, and Mr. Machado admitted to mismanagement. Yes.
Yes. Thank you, Doctor. And you concluded that these two fires eventually converged, right?
Yes.
Now, as you stated on direct, once a fire converges, or excuse me, once two fires converge, it becomes difficult to determine which fire reached a particular point first, right?
Yes. It's almost like they're one thing now.
And that difficulty it's just a limitation of the science, right?
Yes. Yeah. Eventually, it's yeah. I like to say it's like pouring water into water. Once you do it, you're like, which cup was it?
And so because of this, you could have concluded that either fire could have been sufficient to destroy the storehouse, right?
Yes, they could have.
Now, fire spreading doesn't require, or let me rephrase, multiple fires can contribute to the same damage, right?
Yes, as this case. Yes.
And the existence of another fire doesn't erase the impact of the first, right?
No. Yeah. No. I mean, it's both two fires into one. So no, not necessarily.
Now, on direct examination, you testified that you went out to the campground and you examined the burns yourself, right?
Yes,
But that wasn't until 2 months after the fire had occurred, right?
you are correct. Yes.
Thank you, Doctor. Nothing further at this time.
Redirect.
No redirect, Your Honor. We just ask that the witness be excused.
The witness is excused. Defense, please call your next witness.
Your Honor, at this time, the defense rests, and we are ready to proceed to closing statements.
Okay, would anybody like a brief break before we get to closing arguments?
We'd request a 5-minute break before closing arguments, Your Honor.
Okay, let's take a 5-minute break and then we'll come back for closing.
Witnesses were supposed to keep track of time.
Oh, okay. So I just didn't know if I needed help with anything.
No, your judges weren't supposed to do it. Witnesses were supposed to do it.
Okay.
I will drop something in the chat to make sure that they've confer on time.
They weren't taking forever or anything. I just asked early on because I didn't know if if someone needed to do it. I didn't even know what the time requirements are, but I don't feel like anyone was running crazy long or anything.
Figured, but still. All right.
Yeah.
Just checking.
All right, are we ready to proceed with closing arguments?
Yes, Your Honor. Prosecution is ready to proceed.
All right. You may proceed.
Your Honor, permission to reserve any remaining time for rebuttal.
Granted.
Thank you, Your Honor. May it please the court. Your Honor, counsel, members of the jury. If you play with fire, you're gonna get burned. On July 4th, 2023, a group of college students went to Lake Hope State Park to celebrate the 4th of July. And for a while, that's all it was. That was until the defendant in today's case chose to light fireworks. Not just any type of fireworks, members of the jury, but today you heard that they were Roman candle fireworks in a state park next to a dry wooded area on a summer night when the wind was picking up. And that choice changed everything. Because when you play with fire, real fire, you don't get to decide how far it spreads or who it harms. That night, a forest fire started in Lake Hope State Park. And that fire was placed right next to Pat Green's storehouse, and it burned down. And that's why we're here today. Now, when you go back to deliberate, the judge will give you the law. And your verdict must follow those instructions, so I want to walk through all of these together. Now, element 1 is the accused, and the accused in today's case is the defendant, Adrian West. Element 2 is time and place. Well, we talked about that this happened in the state of Eureka, in Hocking Hills County, at Lake Hope State Park on July 4th, 2023, and those elements are not in dispute. But here's what brings us to element 3, and you'll see it says knowingly or recklessly. Members of the jury, the law tells you we do not have to prove intent to endanger. I'm not standing up here today saying that the defendant wanted to start a wildfire. We are simply saying that she acted recklessly. But what does that mean? Recklessly means consciously disregarding a substantial and unjustified risk. Disregarding a substantial and unjustified risk that a result will occur. These were college students. They were not babies. They were not children. They know what fireworks do, much less a firework that's shooting projectiles into the air. Burning projectiles, balls of fire, while facing the woods on a dry summer night with wind. This is the very definition of consciously disregarding a substantial and unjustified risk, and that is recklessness. Now, you first heard from Deputy Matty Fernandez, the responding officer to the crime. You heard that he was dispatched to the Grove picnic area because multiple people had reported a fire. Not a small fire, members of the jury. You heard it was blazing, and it was blazing throughout the forest. When he arrived, the fire department was actively fighting this fire, but he didn't just stop there. He spoke to witnesses. You heard today that he spoke to witnesses who described a group acting obnoxious and then setting off fireworks near the picnic area. So Deputy Fernandez went there, went right where the witnesses pointed him to. And he told you that when he went to this area, well, under one of those picnic tables near Hammond Grove, he found the remnants of a Roman candle firework. A coincidence? Members of the jury, that wasn't speculation. That was physical evidence. You then heard from Kelly Lutkin. And you heard a lot today about how Kelly didn't want to get her friend in trouble. She's 20. She's in college. She has a scholarship. So at first you heard that she denied there were fireworks to begin with. But when confronted, when she understood the seriousness of what happened, she told the truth. And what was that truth? Well, members of the jury, that truth told you that the defendant lit the fireworks. And I want you to pay attention because Kelly did not just say, oh, someone else did it. Yeah, I bought them, but someone else did it. She did not say maybe. She said the name Adrian Weiss. Members of the jury, that is identification. Now, you saw text messages today. Opposing counsel got up here and said, well, the defendant was really upset with her after she, quote unquote, threw her under the bus. But I think it's more important, members of the jury, is what are not found in those screenshots. Nowhere on them do you see any text from the defendant saying, hey, why would you blame me? You're lying. I didn't do that. Why are you lying? You didn't see that. And that silence does speak volumes today. I want to talk about the fourth element, which is causation, because the defense wants this to feel very complicated. Now, the instruction will tell you that an act causes danger if it is the direct, natural, and probable consequence of the act. And the danger would not have happened without the act. A natural and probable consequence is what a reasonable person would know is likely to happen. And here's the most important part. Ladies and gentlemen, there may be more than one cause. Defense counsel spent their entire case today talking about this other fire, and that's great. Because the act does not have to be the only cause. It only has to be a substantial factor. So I just want to be clear. Today, we do not have to prove to you that Adrian Weiss's fire was the only fire. We do not have to disprove every alternative that the defense can imagine today. But we have to prove that her conduct was enough on its own to place that storehouse in danger. And it was. You heard that fireworks were set off near Hayman Grove. Roman candles were found there. Adrian Weiss lit them. A forest fire originated in the park that night, and that fire burned down Pat Green's storehouse. This is causation. If you launch fire into the air next to the woods, well, it is natural and probable that those woods would catch fire. Members of the jury, I beg you not to check your common sense at the door. This is common sense. Now, the defense brought Casey Machado. I don't want his testimony to distract you today, because Casey told you that he was a campground host, not a fire investigator. Now, Casey did not testify to anything revolving the Hayman Grove fire. He couldn't tell you anything about that. Casey Machado does not create reasonable doubt in today's case. And the defense expert told you something important too today. Well, that the Hayman fire was caused by fireworks like a Roman candle. That alone is enough. Members of the jury, the existence of two fires, it doesn't cancel out the first. Their own expert came up here today and admitted that the Hayman fire itself could have caused this damage. You, the jury, are the guardians of behavior in this community. And the law exists to protect people and property. It exists to say that, hey, you can't just go out into public and start blasting fireworks without consequence. Because this case is not just about property. It's about risk. It's about safety. It's about accountability. It's about the reality that someone could have lost their life today. And the law does not ask you to guess intent. It asks you to judge conduct. Adrian West chose to play with fire. And when you play with fire, you're going to get burned. Members of the jury, the state has proven every element of fourth-degree arson beyond a reasonable doubt. And therefore, we ask you to return the only verdict consistent with the evidence and the law. We ask you to find the defendant guilty. Thank you.
Defense closing argument? You can proceed.
Can I proceed?
Yes.
And may it please the court. When you play with fire, you are going to get burned. I mean, that's a true statement. Unfortunately, the fire in this case was Kelly Lutkin, and the person who got burned was Adrian Weiss. My co-counsel told you in the beginning of this trial, in his opening statement, that this is a case about unreliable sources. And let's tell the truth about what happened here today. Prosecution can't prove every element of their case because in order to do so, they are relying on sources that you cannot trust. It was a great closing argument, an impassioned plea. It really was. But the simple reality is that the prosecution in this case has the burden, a heavy burden, to prove each and every element that they are required to prove against Adrian Weiss beyond a reasonable doubt. It is a heavy burden, and you know it's a heavy burden because every single person in this courtroom today is under oath. Before Judge Brown ever took the stand, she took an oath. I'm under oath. Prosecution is under oath. We all took oaths to do our job to the best of our ability to uphold the Constitution. Every witness who took the stand was under oath to tell the truth and the whole truth. And the truth is important here because you are the judges of credibility, and even you are under oath in this courtroom today, under oath to faithfully apply the law in order to uphold the Constitution. And make no mistake about what that means, ladies and gentlemen. You and I have the same job today. It is to hold the prosecution to their burden beyond a reasonable doubt. And they haven't met it. This case is about unreliable sources, and we will begin ever so briefly with the source of the fire. As you heard from the defense expert today, Dr. Cal Stewart, there were two fires. There was one fire in Heyman Grove. That is where Adrian Weiss was. That is where Adrian Weiss was, unfortunately, with Kelly Lutkin. And then there was another fire that began in Daleville. You heard that the fire in Heyman Grove was caused by fireworks. You heard that the fire in Daleville was caused by a mismanaged campfire. And those two fires spread wildly due to the wind, traveling different routes. We don't know which one was going to get to the building first, but because of the routes that they took, eventually they converged, and that resulted in this building being burnt down. So let's just concede it right now. Let's just concede it. Yes, those fires merged together, and that single fire, that is what caused this building to burn down. We don't actually know which one would have gotten there first, because that's not what happened. I don't need you to engage in speculation. That's what the prosecution is asking you to do today. What we know is that that fire caused that building to burn down. That is not a distraction. That is an expert talking about what actually happened here. Something that the prosecution actually failed to present to you in their case in chief. The real story here is about the elements that they cannot prove beyond a reasonable doubt. And you know that because the prosecution went through the first element of this crime at lightning speed. The first thing that they are required to prove is that the accused was the one who started that fire. The accused, Adrian Weiss. You saw the Roman candle today, this firework that supposedly caused this fire. Here it is. Investigating officer was forced to tell you under oath he couldn't take any fingerprints from that Roman candle. There was no DNA evidence. There was nothing that actually connected that Roman candle to Adrian Weiss. That physical evidence, it doesn't exist. And because it doesn't exist, the only way that the prosecution can connect it to Adrian Weiss is to put an unreliable source on the stand. Today, they rested their case on the testimony of Kelly Lutkin because no one else can put that Roman candle in the hands of Adrian Weiss. And because you are the judges of credibility, I want you to really, really think about the testimony that you heard today. I mean, the witnesses got on that stand and they swore under oath to tell the truth. But the only person who could say that it was Adrian Weiss who started that fire was Kelly Lutkin, a person who has admitted that she has repeatedly lied in this case. Why? Because she has something to lose. That is powerful motivation. Kelly Lutkin was spoken to by the officer investigating this case. The first question that she was asked was, did you have anything to do with this fire? It wasn't us. I swear it wasn't us. That was her answer. And she admitted on the stand today that that wasn't true. That was a lie. Again, she was confronted with more information. The pressure was put on her. And once again, it wasn't us. She lied again to a police officer. A third time, was it you? No, I swear it wasn't us. And it wasn't until she was confronted with the photograph of the Roman candle that she finally changed her story. Did she take accountability? No. I mean, the prosecution needs you to believe that that's what happened. The pressure got to her. All she was trying to do was to protect her friend. But you also heard today that she had a lot to lose. She had a reason to lie. And so she blamed her own friend, Adrian Weiss. In her closing arguments, the prosecution, they stood in front of you and said, you know what you don't see in those text messages? The defendant didn't say, hey, you lied, you blamed me. They want the defendant to prove that she is innocent. They want you to hold the defendant accountable for proving that she's not guilty. Well, that is not how this works. The burden rests with them. It stays at that table. It doesn't get lighter, it doesn't get easier, and it never switches shoulders. It is on their shoulders, and they haven't met it. Ms. Suttles told you that you are the guardians of safety and accountability. And she told you that the law doesn't ask you to judge intent. Let me tell you, ladies and gentlemen, intent is not important in this case. It doesn't matter in this case. And you know why it doesn't matter? Because in order to ever talk about intent, to ever talk about whether this was reckless, to ever talk about whether this is knowing, they had to prove to you beyond a reasonable doubt that it was Adrian Weiss who started that fire. And they cannot do it. When the government doesn't have the evidence, the prosecutor is going to stand up in front of you and tell you that you are the guardians of our community so that you feel important. so that you feel like when you go back to that jury room, you have a job to do to protect the community, to keep them safe from people like Adrian Weiss. But the problem is they never actually prove to you that Adrian Weiss committed this crime. And so they need you angry, they need you impassioned, they need you motivated when you go back to that jury room, because if you're motivated, you are more likely to put a checkbox next to guilty. But we have a job to do today, to hold the prosecution to their burden beyond a reasonable doubt. Not speculation, not she could have started the fire. Beyond a reasonable doubt, Adrian Weiss is guilty, and they cannot meet that burden. And because they have failed to meet that burden, you must put not guilty. Do not allow them to get you to do the work when they rested their case on unreliable sources.
Any rebuttal from the prosecution?
Yes, Your Honor.
You may proceed.
The defense wants you to believe that this case is about unreliable sources, but it's not. Unreliable sources don't leave Roman candle firework remnants behind. Members of the jury, the physical evidence didn't change. And I agree with defense counsel that it is important to tell the truth. That all of us are under oath today. So then take into account that under oath, the testimony matched the physical evidence. Mr. Lane got up and told you that I said you were the determinants of safety in our society because I want you to feel important. That's not why. Members of the jury, you are important. Because you understand what was at stake. Now today, under the same oath that we are all on, Kelly Lutkin understood what was at stake for her as well. And she had something to lose. And when it mattered, in front of each of you, she told you one name. The defendants. And she got up here on the stand today and she said that she was ready to accept the consequences, even for herself. But she still gave you that one name. Two fires do not erase the first. And the law does not require us to prove that this fire was the only cause, only that it was a substantial factor. Because if you play with fire, you're gonna get burned. And ladies and gentlemen, the evidence today, well, it showed you who lit the match. So when you're asked whether or not to hold the defendant accountable for this crime, I want you to find her guilty. Thank you.
All right, I think that's the case.
Can the judges please, before you before you give any feedback, make sure you fill out ballots for me.
May we take a brief recess, Your Honor? You're muted, Judge Brown.
There we go. Yes, we can take a break because I need to fill out my ballot.
Excellent. I'll be back in 3. Maddie, I'm calling you.
Okay.
I'm back.
All right, for the judges, have y'all submitted ballots?
Yes. Yes.
I have all ballots. You can get started.
Okay. I'm gonna let my colleagues go first. Whoever wants to go. I presided, so I'm gonna be quiet for a little bit.
All right, I'll go. If you don't know me, my name is Seppi Zimmer. I'm actually an assistant district attorney in the Harris County DA's office. I am the chief of our digital forensics, and I actually did spend like 4 years of my career in our major offenders division, where for a part of that, I actually exclusively handled homicide and arson investigations. Actually, I was the only prosecutor in Harris County that handled all the arson intakes. I say all of that to say I always hated arson cases. They're really, really hard for the state. And so I applaud you guys for getting through what is otherwise a not sexy and always a boring kind of topic, and hard to prove. They are very hard to prove. So I thought you guys all did a really great job. I'll just go over some of the little things that I wrote. Anthony, I think you have such a great control, like just straight from like introducing yourself to like kind of stealing that control from the prosecution and getting straight into motions in limine and your arguments. I feel like every time you spoke, you had really good control of the courtroom. Considering doing all this stuff on Zoom is like terrible and really hard to do, I thought you guys all did a great job in that way of like your presence. Alejandro, I think you did a good job with your opening statements. That's always hard to do on Zoom. I hate doing any kind of arguments or closings on Zoom. I would work on just changing up your tone a little bit. Again, I'm sure Zoom played a bigger role in that than you otherwise normally would do. Let's see. Jeffrey, your opening, I thought you did a really great job of like that classic, what I think the defense had to do in this case of like, hey, this is a tragedy, but the bottom line is they can't prove it. I thought, especially coming right after the prosecution, I thought that was a really compelling opening statements. I thought you had a really great presence doing that as well. Let's see. I thought you guys also did a great job, Alejandro, of like just getting ahead of the bad facts about her lying to the police. Because by the time the defense got into that cross, it was kind of like they really harped on it and went line by line on it, but it was already kind of not important anymore because they did you guys did a good job of getting ahead of it, as bad of a fact as that would have been for you. And then Anthony, when you did the cross of her, I thought you did a really great job of pointing out like, hey, this was your idea. You were like willing to go drive to another state. You took a really long time. And now all of a sudden you're trying to pretend like you don't like fireworks and you didn't even light any of them. I thought that came across really well, attacking her credibility. Maddie, you had really great presence. I love your voice. I love your pace. Great responses to hearsay. My one advice for you to be, if you ever, especially when you're the prosecution, be careful about your objections. I thought all of your objections were actually like spot on, but particularly about when you're coming from the prosecution, you've got to really like manage and like master that skill of objecting when you need to, not when you can. It really hurts the prosecution whenever you look like you're hiding something or bullying the other side, and I think you were right in all your objections, legally speaking. And also this is just a very like, judge, you might disagree with me, but one of my biggest pet peeves is like when someone argues something to keep something out, it gets sustained, which you did. And then like 2 seconds later, you're like asked and answered. It's like, well, yeah, he probably is asking and answering, but it's because you've sustained it and you're making him reestablish some sort of predicate again, right? So if you do get something sustained, you won. Don't then like 2 questions later be like, judge 30 asked and answer this. And it's like, yeah, we know he did, but then you made him start again, you know? But Jeffrey, on that line, I thought you did a really great job with fixing and responding to objections. I thought they were really great responses, and then fixing your questions so you could still get your answer out. But overall, I thought everyone did a really great job. I loved the closing arguments on both sides. I loved the points that you guys made. But yeah, I thought you guys all did a great job.
Thank
Thank
you.
you.
Who
Nick,
wants to
you go
go?
next.
All right, I'll go next. Alejandra, I liked your opening. I liked your, you were clear, concise. I understood what you were saying. One thing I wrote down was that, and some lawyers are going to disagree with this, I'll tell you that. But you said the defense might get up here and talk about another fire. You're right. They might, but I mean, some lawyers don't go this far, but whenever something's that clear, like they have to talk about something, or else it's malpractice, essentially, in a way. I tell the jury, look, they're gonna harp on this fire. Mark my words, they're gonna talk about it, and yes, could it end up biting me in the, maybe, but when it's something that clear, I like to be a little more firm on that, and that's nitpicky stuff that I've just picked up in practice. Um, Jeffrey, I love the fact that you came on and stood up. And I know we're on Zoom, so it's a little different. And I remember like the first couple of times, it still feels awkward to me when judges like Judge Weems or Judge Brown say you can stay seated at council table, right? Like it's a weird thing, and I think it's always better to stand up. I think it makes me feel better. I feel like I'm getting my message across better, and I like the fact that you did that. I liked your opening. Um, I thought you did a good job. I think you did great. Um, Really, I'm only commenting on opening and closing. I thought the witnesses were all great. It's a tough case. I'm not a criminal lawyer. There's a assistant district attorney on here that knows a hell of a lot more about criminal law than I do. So I'll let her chime in about one other thing I wanted to say is I may have missed this during opening, Jeffrey, but I don't remember if you said anything about the burden. Um, you may have, and if I'd missed it, I'm sorry. But um, you know, I can't tell you if a defense lawyer ever stood up in court. Well, I'm a plaintiff attorney, by the way. I've tried one defense case. If a defense lawyer ever stood up in court and forgot to tell the jury that the burden was mine and that it was preponderance of the evidence, it would be like a gift to me. Okay. In fact, that's the one thing I say during my opening that I promise the jury they're going to hear about. They're going to harp on this burden. You're going to hear it, blah, blah, blah. We're going to meet it. And Alejandro, you kind of did that. I thought both closings were excellent. I really did. I had my ballot up on my phone. I wasn't texting the whole time, I promise. And I mean, I just kept, increasing the score. I thought y'all both did a great job. Maddie, my wife has been in the room for part of this. She's like, she has a great voice. She's got a great tone. Um, and then Anthony and I agree with her. And Anthony, you got up, and I was like, this guy's kind of got my style. You're kind of fired up, heated up, and aggressive, and I like that. One thing I will say, and this is again me being a plaintiff lawyer, is Maddie, rebuttal it's a gift. Okay. Like I said, I've tried one defense case and it drove me crazy not being able to get the last word. You did a good job with your rebuttal. It worked for you. You were still calm, cool, collected with the right tone. Me, when I get up on rebuttal, it's like when I come out fired up. But you got to be you, or else the jury will pick up on it and know that you're being fake. Okay.
Real quick, before Nick keeps going, I have one question. I need to figure out real quick. All right, who did the first plaintiff prosecution direct?
Alejandro.
That was me.
Alejandro.
All right, who did the first cross? Who crossed that witness?
Anthony.
Anthony.
All right, and so I can figure out to Alex, and then Maddie. Hold on, I got a dog. Sorry. And then Anthony, and that was Jeffrey. And then who did the first defense direct?
Jeffrey did.
Who did the first cross?
Maddie, I believe.
All right, and then Anthony, and then Alejandro. Okay, great. Sorry.
No, you're good, Judge. I like that whenever you get a chance to do the rebuttal, even if you're, if there's one thing you do while the defense is closing, pick something out that you can get up and shove down their throat. Okay. The defense's throat. And you did it, Maddie. I heard him say they want you to feel important. And I sort of was like, oh, shit. Like, Anthony, nothing against you. It sort of stuck out. And I'm like, uh-oh. And sure enough, you got up and you said, he told you that I want you to feel important and I'm doing this because no, you are important. That's what you have to do. Okay. That's a good job. Anthony, nothing you can really do because you're a defense lawyer in this case, and you don't get to get back up and save it, but you got to be careful what you say because a good plaintiff lawyer or prosecutor like Ms. Zimmer will get up and shove it down your throat. Overall, I thought y'all all did great. Obviously, you got to this stage of the game or the competition. Y'all did great. I think y'all were all well prepared, which at the end of the day, that's everything. So I appreciate y'all letting me judge. It was nice to see all y'all perform and wish you the best.
Thank you so much.
Thank you.
Yep.
Hey, I'm Andrew Birdsell. I'm also a plaintiff's attorney and well, working on being a mediator now, but tried a bunch of car wreck cases mainly, both on defense and plaintiff side. But I'm not a criminal lawyer by any means, but I did take a bunch of pleas at the beginning of my career. That being said, I mean, I echo a lot of what they've already said. I mean, so I don't need to repeat it over and over again. I don't want to criticize, but if you're going to make a speculation objection, make it during the question instead of like after the answer has already been given. It's just a matter of timing. I thought that considering everybody had to transition from being in person to Zoom, you all did a really good job at that. I've only done one Zoom trial and it was awful. I just could not. I mean, I was okay with managing exhibits and stuff, but it's very awkward to try and be passionate and get your story across, which is what you're all trying to do. And I think you all four of you did a really great job as far as putting on your cases. It was very, very good. I was gonna say, I think, and you both came out of the gate on the openings very good. I thought, what did I write down? I can't even read my handwriting. Well, anyhow, plaintiff, or excuse me, prosecution, I thought you came out really good. I just wish that I know you were talking about how your counterpart was going to talk about the burden of proof at the end. I think you should still touch on it at the beginning so that the jury has an understanding of what they're looking for you guys to prove, and that you're going to prove it beyond a reasonable doubt. I mean, and I don't think you need to spend a ton of time on it, which I think you didn't want to do. But I think if you spent 25, 30 seconds just explaining it, that would just give a little more, credence to what y'all are doing. But I think both people got across their stories very well in their opening, and then I think you did a good job bringing it out during your questioning. And I'll just go real quick to the close. I thought the closings both were just fantastic on both sides. I was really, really impressed with that. And I agree with what Nick said about having getting your chance to do the rebuttal at the end is so fantastic, and you really took advantage of that, Maddie. And I think Anthony, you had a really great presence of the righteous indignation that you came across with is fantastic, and that's the most fun thing to do when you're in a courtroom. If you can have enough time without anybody objecting and breaking your stride during a closing statement, which is I look, people have done it to me while I'm doing a closing, and I've done it to them while they're doing a closing because, damn it, if they are on a rant, you need to stop them from doing so. None of you guys did that. I think you probably should have, but that's a separate issue. That's a real life thing. And, but it was really good. I think you came across really well, but again, you cleaned it up really well, Miss Suttles, and I think it was just very, very good. So I'll just leave it at that, but I think you guys did a very good job.
Thank you.
All right, so I'll go last. I'm Denise Brown. I'm the presiding judge of the 127th. It's a civil court. I know nothing about criminal law, so much so that I didn't even take criminal procedure in law school. I just learned what I needed to learn for the bar. So if I got any of the some of the rulings I ruled improperly because on purpose to see how y'all would handle it. But also, if I happen to rule something that is not the way that it would be ruled in criminal, then it's because I'm not a criminal judge, not a criminal lawyer. I was plaintiff right before I took the bench. I also did defense work in the beginning of my career. So this is just going to be kind of I don't want to say nitpicking, but more specific because I'm just going to echo what has already been said. All four of y'all are fantastic. Y'all were able to try this Zoom case or this case on Zoom better than some lawyers who appear in front of me for trial. Experienced lawyers at that. So as far as the burden of proof, which has already been touched on, in the civil side, if you don't mention the burden of proof as a plaintiff, it looks like you're hiding from it because you're going to get nailed with it from the defense. So, like Andrew said, just saying something for, 10, 15 seconds, this is what the burden of proof is. Y'all have already heard about it on TV, beyond a reasonable doubt. That's the one that everybody knows. This is what it means, and we're not afraid of it because we're going to meet it. And then you go on. As far as the witnesses and the direct and crosses, I think everybody did a really, really, really great job on direct because direct is super boring. It's really hard to do a direct where, because the whole purpose is not what you say, it's what your witness says. And so y'all were able to take that back seat and let your witness shine. But you were able to do it without it being super awkward. And Anthony, your direct of your expert witness, the rapport that you two had was fantastic. That witness was also testified very much like an expert. So if he's not an expert currently, he may have a future of that. And, I don't know. But y'all had a really great rapport. Let's see. I had to switch pens in the middle of it because my pen ran out of ink, but so I had my trusty pencil. So my notes are all weird. When it comes to the police officer, there were really succinct responses to the hearsay objection, Ms. Suttles. I thought that was fantastic. You knew your response, you knew what you were going to say. It wasn't a whole lot of kind of dancing around. And for the cross-examination, it was really good about staying on the witness to get the answer that you needed. The threat of the threats of arson means that she changed the story, that the story didn't change until there were the threats of arson charges. That was fantastic. The motion for acquittal, I don't know if that would have happened in a criminal court. I don't know if it would have been granted. It seems, arson and these problems are super hard to do. But it was a good motion. I wrote down the relevance objection. I think it was the same thing that was previously mentioned about if you're going to object to the foundation, don't then object to the relevance or to the asked and answer and that sort of thing. Be very careful of what you're objecting to and how you're doing it. Overall, this is just probably, it's a problem issue. I don't know why Mikado was a witness. But as far as the expert, it was good on both sides. It was a good direct, it was a good cross-examination, and the closings were both phenomenal. Super phenomenal. The calm and cool collectiveness of the prosecution of we've done our job and you have no choice but to convict versus the defense going, how dare they insinuate that they've done their job, to coming back and going, we've done our job. You have no choice. I think it was fantastic. So kudos all around.
Is that everybody? I'm sorry, I had to step out for a second. I've got kids, I've got dogs, I've got cats. It's all chaos, but it's all right. It's such a close round. And when I mean like such a close round, I've been like struggling to do math and I don't even know if, and this is why, so first off, the award for outstanding advocate was super duper close to, which is why I need to know who did what to be able to do the math on that. And then on the ballots, I'm gonna be upfront with y'all. No margin. The margin on all the ballots for 3 of the 4 ballots was only by 2 points, and 1 ballot was tied, so it went to a tiebreaker. So, like, legitimately, this is probably one of the closest final rounds we've ever had for a competition. So, first and foremost, kudos to both teams, Maddie and Alejandro, and Anthony. And where did you go, Jeffrey? Where did Jeffrey go? Oh, there he is, in the middle of my screen. Amazing job to all of you to make it here. And to be clear, I mean, as of like a week ago, Maddie and Jeffrey were co-counsels in a case, and as of a week ago, Alejandro wasn't even going to be competing. So amazing, to say the very least. So first and foremost, the outstanding advocate of the final round, which, like, this whole round has been split ballots on everything, but still barely edged out second place, was Anthony Lane. Congratulations, Anthony.
Yeah, thank you.
But the winner of the 6th annual death match, sponsored by Armstrong Lee Baker, who wins the custom tailored suits donated generously by Troy Chandler with Chandler McNulty, and the boots courtesy of Nick Ware with Kirker Garcia. Thank you, Nick. So 2 of y'all are gonna have to thank him right now while he's on the call with you. Is Team Overrulers, Maddie and Alejandro. Congratulations, y'all.
Congrats, y'all. Good job.
Thank you so
Congrats.
much. Thank you for the boots.
Yes,
Really
thank you,
Oh,
Mr.
very
appreciate it.
good.
No worries. I'll get Weems Judge Weems the gift card soon.
Thank
I've got
Thank
him
you
here,
so
but I'm not
much.
at the courthouse. So
And I know we're not
neither
in
am
person,
I.
but Anthony, Jeffrey, I'd shake your hands if we were.
Yeah.
Great round, guys.
Seriously.
Yeah, great job, y'all.
There you
Fantastic.
go, man. Maddie, I love you so much, man.
I
Good
love you
deal.
so much. Congratulations.
Killed it.
Can I
both of you
take
guys.
a
All 4
Zoom
of you.
picture with everybody on it real quick? I know it's super cheesy, but like, even all the coaches and all the witnesses, just to have, because we would do it live. If we were live, I'd make you all take a picture together. But since we're not live, I'm gonna make you do it all over Zoom. It's all the witnesses who are left and the coaches. Yeah, I see all 4 witnesses, all the coaches, all the judges. All right. Let me make sure I do this right. Everybody smile. Why is it always dark in your world, Avon? Your world's always dark. It's all right. I'm just messing with you. Everybody smile. Thank you. All right. Let me make sure that I got it, because sometimes I don't. Petition for Ruby. No. God, that dog is like barking. Y'all are cheesy. Let me just make sure that didn't show up in the picture. It did. We have to do it again. Because stop texting things in the chat. I'm trying to take a picture. Smile one more time. Nick, look down. Why are you looking up?
I'm about I was laughing.
Okay, smile. All right. Let me just look. Make sure we got it. Everybody's like, God, we're so tired, Weems. I get it. But I want to have it for prostate. No, hold on. This is, oh. Let me get rid of this. One more time with feeling. All right. Hopefully this will be it. All right. And no, stop. Sorry, windows keep popping up on my freaking. All right. All the notifications need to go away. There's nothing in the chat. Tristan, look forward. For some reason, you're looking off to the side. There we go. Stop. Yeah, there, stop. Look there. Look there. No, look down. There we go. Stop. Smile. And oh my God, please tell me this is it. Where did my somebody else do it? Can somebody else take a print screen and a screen share? This is not working for me
I
today.
would be more than happy to. Everybody smile in 3. I got it, Judge. First try,
Right.
'cause I'm a beast.
Was I
Nice.
blinking? Was I blinking, Anthony? Check.
Oh my
If not, I managed to finally get one too. So
Yeah.
between the 2 of us, we got it. All right. Thank you all so much.
Thank you. Great
Proud
job, you
of
guys. Hi,
Thank you.
all of
Yusuf.
y'all.
Thanks, everybody.
Thank
Good
everybody.
job, everyone.
Judges, thank you
Bye.
so much. Appreciate you. Everybody stay safe, stay warm out there.
All right, bye.
Ooh, Maddie,
All
I'm
right.
gonna call you again.
Okay, bye.
Bye-bye.
Do we want to talk to coaches first? I'll call you later.
Okay.
You want me? All right. Well, I'm going to stop the live stream at least. Y'all want to talk to your coaches? You're more than welcome to.
Can
Everybody
we go
else
to
is
our
free.
breakout rooms?
You absolutely
Sure.
can.
Coach, do you want to talk to us?
He's
I
like,
want to
I got
talk to you
nothing.
guys. Yeah.
Yay.
I
Okay.
got nothing to say to you. No, just kidding. All right. I'm trying to.
Great job, y'all. Yeah. See you later.
Done.
Breakout rooms. There we go.
Yeah, I'll leave the Zoom open for y'all.